to Judge Alito, and thank you for taking my call.
Thank you. The nominees come back. The committee will gavel in shortly, set to come back at 2 o'clock. We're right about there. The woman at the table with Samuel Alito is Rachel Brand. She is the Assistant Attorney General in the Office of Legal Policy. She's actually, by the way, involved in the preparation that the judge went through for the hearing. She is going to be our guest on tomorrow morning's Washington Journal and will be on with us live at 8 a.m. Eastern.
And it is now Senator Biden's turn for his second round for 20 minutes. Senator Biden.
Thank you very much, Mr. Chairman. Judge, good to see you. As I said to you, we happened to run each other in the hallway coming in. What I'd like to do, if I may, is go back and revisit two areas that you were questioned on yesterday, and a little bit, maybe even today. I don't recall, actually. I think it was yesterday. And one is the Casey case. And I want to make sure I understand, because I'm still a little bit puzzled by your reasoning. But let me start off and make it clear. From my perspective, the abortion issue is I'm trying to figure out how you arrived at interpreting a Supreme Court justice's standard that was being applied and how it came out differently than others. Yesterday, you said, when I think it was Senator Cole asked you, that you agreed with Justice O'Connor, quote, that you look at the group that's affected, not the group that's unaffected. But when you wrote your dissent, you said, and I quote, it seems safe to assume that some percentage, despite an initial inclination not to tell their husbands, would notify their husbands without suffering substantial ill effects, acknowledging some would suffer substantial ill effects. Can you tell me, rationalize yesterday's statement and your dissent for me? Tell me, explain it to me.
Well, I think what you look at is the group that is required to notify. You don't look at the group that's not required to notify. Right. So unmarried women are not examined here because the notification requirement obviously does not apply to them. Then my understanding of Justice O'Connor's standard, which was the more than some woman standard, let me put it that way, although she didn't put it quite that strongly. She said that it is insufficient that some women are inhibited from having an abortion as a result of the requirement. So you look at the people who are affected by, who are within the scope of the provision, and then you would see how many of the people within the scope of the provision would be inhibited from having an abortion as a result of what was involved. You don't look at people who aren't regulated at all, and you don't just look at the people who would be inhibited, because both of those would not be the right thing to look at. So in the case of, let's take the case of the informed consent requirement. You'd look at everybody who was required to receive the information that was within the informed consent provision, and then you would ask how many of the people, how many of the women who are regulated by this would be inhibited from having an abortion as a result of the requirement. That was my understanding, and that is my understanding of what she was talking about.
Now, you referenced in your dissent in Casey the Thornburg case. What was the issue in Thornburg?
Thornburg concerned...
that prompted her to come up with a statement that you referenced, which was that, it doesn't have to affect everyone.
Well, she was setting out her understanding of what the standard was, of the undue burden standard. Now, in Thornburg, there were several provisions of a previous version of the Pennsylvania statute at issue. There was an informed consent provision, as I recall. There was a provision relating to health insurance. There was a provision relating to notification of a minor's parents. There were a number of provisions involved, my recollection is that when she made this statement, she was talking about the undue burden standard itself. It was an explanation of what she meant by the undue burden standard.
As I went back and read it, my understanding was, and I won't, in the interest of time, read her entire 2 paragraphs here, but that the part of Casey which she found to be a particular problem as being declared unconstitutional by her colleagues was where a doctor, an obstetrician, would have to read to a woman certain verbiage that would explain the pros and cons about an abortion, or at least the downsides of an abortion. And she said a state has an interest in promoting life. And so even though some women might be offended by that, it was still okay. It was still constitutional. And that language is the language that the discussion about even though some women would be affected, you transposed and in good conscience to a case where notification to a husband was required. And one of the things that I had some difficulty with is whether or not there really were comparable issues here. In one case, it was about whether or not a woman would fear for her life, for example. An exception was given if she informed her husband. Another case, it was not about that. It was that O'Connor was referring to. She was referring about whether or not it put an undue burden on a woman to be told, by the way, this can happen when you have an abortion, and this is a state where the fetus is, et cetera. And that's the part that kind of disturbs me, or that perplexes me anyway, about the real world here. I mean, Senator Specter referenced the Violence Against Women Act. We did a lot of work on that. There's overwhelming evidence that there are women who would be fearful of going home and telling their husbands they're going to have an abortion, not fearful physically, fearful that the husband had all the economic power and say, I'm divorcing you and I'm taking the kids and having a custody battle, and you don't have the money to hire a lawyer. Are they comparable ill effects? That is that kind of ill effect, and a woman that if she tells her husband he's going to sue for divorce and seek custody of the children, knowing that he has all the economic horsepower and she has no ability to go out and hire a significant lawyer, is that comparable to the doctor saying, by the way, if you have an abortion, here's what happens?
The informed consent provision presented an easier isn't even the right word, a less difficult question than the spousal notification provision. I don't think there's any question about that. They both involved the same standard, which was the undue burden standard. And therefore, I thought, and I still think that what's said in reference to one provision is relevant in determining what the standard was. The big issue when this case was before us was whether the standard was undue burden or not. It's funny how cases look different after they've progressed through the Supreme Court than they do when they're first presented to the Court of Appeals. That was the most hotly contested argument before us. Had there been any change in the Supreme Court's case law, and the plaintiffs argued strenuously that there had not, but our panel, after some effort, determined under the Marx standard for determining what the holding of a case is when there's no majority opinion, that the standard was the undue burden standard. And there just wasn't a lot to go on. I think I said that yesterday. I looked for whatever guidance I could find.
Well, again, I'm not questioning the sincerity of your search. Again, it gets down to the thing that keeps coming up with me is not that you don't care about the little guy and all that. That your reading of statutory language, Supreme Court precedent, the Constitution, seems to me to not reflect some of the genuine real-life differences that exist. The idea that you acknowledge that some women would suffer ill effects, substantial ill effects from informing their husbands, but because it was only a small percentage, that met the undue burden test. I didn't meet the undue burden test. Seems to me, well, anyway, the majority disagreed with you, and I happen to disagree with you because I guess maybe it's because we've been so exposed to how so many women are within their relationships can suffer significant consequences for challenging a position that their husband does not want to accept, whether it has to do with abortion or what school their child goes to. And it's pretty consequential. But that's my problem with how you arrived at your reasoning, or your reasoning and how you arrived at your conclusion. Let me move on to another area in the interest of time here. Yesterday, there was discussion about Family and Medical Leave Act, and you correctly stated there were two distinct parts to the act, and the Hibbs case dealt with one, and the case which you were, Chittister, dealt with another. Can you explain that again for me?
Yes. Hibbs concerned a provision that required employers to give employees leave to be out of work to take care of a family member. And there was a record that employers, state employers, had given more leave for this purpose to women than they had to men, and that was based on a stereotype that when somebody in the family gets sick and somebody has to leave work to take care of the family member, it's the woman and not the man. And it reinforced the stereotype, of course, because having such a policy would put pressure on women to leave work for this purpose as opposed to the man. If there was a woman and a man in the family and somebody had to leave work to take care of a sick family member and you have a plan like this is going to pressure the woman to do that. So the Hibbs court found that that was a sufficient record of gender discrimination to justify the passage of legislation under Section 5 of the 14th Amendment. Chittister concerned a provision that related to leave for personal illness. And there's no reason to think that men or women get sick more often, one than the other, or what was to the point that state employers had given men more sick time than women or women more sick time than men. And so with that record, it was the conclusion of my court and I believe 7 other circuits that this was a different issue. These cases were decided before and after Hibbs, and that could not be justified if you accept the congruence and proportionality standard.
Well, on the congruence and proportionality standard, we in the Congress thought we were speaking to that, because were you aware, or your colleagues, well, speak for yourself actually, now you can't speak for them, that 1 in 4 people taking sick leave under the Act are women for pregnancy-related disabilities, and that when we wrote the law, we said explicitly that working women, we wanted the bill to protect working women from the dangers that pregnancy-based distinctions could be extended to limit their employment opportunities. I mean, the practical world is that a fair number of women who are pregnant are told in the last, and I yield to my doctor at the end of the dais on the other side, but it's not unusual for a woman to be told that she needs to, the last month of pregnancy or 2 months of pregnancy, have bed rest. And that if that counts against her 12 weeks, employers, we did establish there's a record where employers say, hey, look, man, we're going to give men and women the same leave, notwithstanding the fact that women, in fact, in many circumstances, and 1 in 4 of them are pregnancy-related, need more time because of the pregnancy. I mean, was that discussed by you guys?
I'm quite certain it never was. I would have made a reference to it in the opinion if that had been mentioned, and I'm not aware of that coming up in the other circuit opinions on the issue. We are, to a degree, we can't know everything about the real world, and we're dependent on the arguments that are presented to us to a degree. I don't believe that argument was ever presented.
Well, Congress expressly stated that the purpose of the act was, quote, to minimize the potential for employment discrimination by ensuring generally that leave is available for eligible medical reasons, including maternity-related disability. And that's why the decision confuses me. I think all you probably have to do is turn to your wife and say, hey, you know, the real world, when you're pregnant, does that sometimes inhibit the amount of time you're able to, you're required to be away from your job? Fortunately, most women, like my wife and my daughter-in-law work up to the time, but a lot can't. Well, look, let me suggest also, as I said to you in the hallway, I want to kind of set the record straight on Princeton. One of the reasons why I'm perplexed, and many of us are perplexed, by your answers regarding the CAP, the organization, is that it doesn't fit with your background. It doesn't fit with your background. As we both said in the hallway, you know, I read your opening statement again, and where you said that a generation earlier, I think that somebody from my background probably would not have felt fully comfortable at a college like Princeton. And I pointed out to you, I'm about 10 years older than you. That's how I felt. That's what I was referencing yesterday about my, Irish Catholic kid from Claymont. And the thing that surprises, or at least puzzles me, is that it was kind of, I thought, a pretty widely known debate that in the Ivies, the one sort of last holdout, fighting to not admit as many women and fighting not to admit as many minorities, was Princeton. And there was a whole battle over it, as you heard referenced, in terms of, the Wall Street Journal, the mailings to alumni. And I noticed someone in the press said, I want to be able to continue to wear the hat given to me by pointing out that the reason I can wear this hat proudly today after being on campus as much as I have at Princeton is today 28.7% of Princeton's undergraduate population is minority. And today, the class of 05, 47% are women. And so that's what that battle was all about, a lot of us thought. I'd be proud if my daughter were at Princeton Graduate School instead of Penn now, although I'm very proud she's at Penn. But that's what this debate was about, Judge, and that's why it still confuses me. And I'm going to ask you a straightforward question, and I hope it doesn't offend you. When you listed CAP, was part of your rationale for listing an application, you thought that would appeal to the outfit you were applying to, the people looking at your resume?
Well, Senator, as I said, I don't have a recollection of having anything to do with CAP. So all I can say is that I put it down on the 85 form, and therefore I must have been a member at around that time. And that's, I can't say
I'm not even suggesting about whether you were or were not remembering, but I mean, was part of the reason, one of the explanations, I'm looking for a reason. I'm looking to be able to say, because you don't impress me as someone, especially from your background, that would want to keep Princeton as, I won't go back and read the quotes, keep Princeton as, imagine my father's 50th reunion having 40% women, isn't that awful? You don't impress me belonging to that club.
I wasn't.
And so the only explanation I can think of, and you're not, you're a very informed guy. I mean, you're sitting up there in North Jersey as a U.S. attorney. As I said, it's in the Wall Street Journal. It's a debate going on. You're getting letters. Only thing I could figure is you figured that, a relatively conservative Reagan administration Justice Department say, hey, maybe that's the kind of guy I want. I can't understand why else you'd put it down. But if that's not the reason, and it's just, you just listed the outfit you belong to, that still perplexes me. But anyway.
Well, Senator, I wasn't a member of that club as you referred to it. By the time I entered Princeton, there were many minorities in my class. That the practice of not including minorities had ended. My class was not coeducational when we were admitted. And as I said yesterday, I had never previously attended a non-coeducational school.
You had about 300 women, if I'm guessing right, when you got admitted, roughly. When were you admitted?
I was admitted in 1968. It was not coeducational. It went coeducational while I was there.
71 70, 71, there were 300 women. Now there's 2,100 in that same class. Anyway, I thank you very much, Judge. I yield the floor.
Thank you very much, Senator Biden. We now have both Senator Durbin and Senator Coburn present. Senator Durbin, you've asked for 2 minutes as a matter of personal privilege.
Thank you very much, Mr. Chairman, and I will make it brief. In a courtroom and in a committee room, it's not unusual to try to rehabilitate a witness, and when hard questions are asked, people come back with information. Mr. Gillespie and his team is down there providing information, and others. Perfectly acceptable. We do the same thing if the shoe were on the other foot. There were 2 personal references to me after I left the room, and I apologize for leaving the committee room. One related to the fact that I had earlier been in a pro-life position in my political life, and it is true. I made reference to this in my opening statement. I've stood for election more than 12 times in the House and the Senate, general and primary, stating my position as pro-choice. So the voters of Illinois know that. I had asked Judge Alito whether his position had changed from 1985. That was the nature of my questions to you this morning. I don't consider that to be a shortcoming if you would concede it changed, although at this point you have not made that concession. Abraham Lincoln was once accused of changing his position on an issue, and he said, "I'd rather be right some of the time than wrong all the time." And so I don't think changing your mind is necessarily condemnation. The second point I'd like to make specifically is my reference to settled law. Roe versus Wade is settled law, and I'm sorry that Senator Hatch is not here at the moment, but I would like to read into the record exactly what was said on September 13th, 2005, before this committee, when Senator Specter said,
Does this involve Senator Hatch?
It does. Senator Hatch raised the question that I had said that this position would...
Shouldn't we have Senator Hatch here?
If you want to wait, I'll wait.
Yes, I'd like to wait for Senator Hatch to rise. That way we may be able to conclude this not in 2 minutes, but in less than 2 hours. I have made inquiries on the Rush issue over the lunch hour, and I have some things to say about it, but I'm not going to say them until Senator Kennedy arrives. So I've asked staff to inform Senator Kennedy that I await his arrival. And in the meantime, if it pleases this august body, we'll proceed with the hearing. Senator Kyle.
Thank you, Mr. Chairman. I do want to tie some loose ends up, and one of them makes reference to something Senator Kennedy read. Would it be okay if I proceed with that? I think it would be fine. And this has to do with this last matter that Senator Biden was also discussing, and that's the Princeton Alumni Group. Just to make sure that the key facts are understood here. You believe you joined Judge Alito around 1985 because of a concerned threat to ROTC at Princeton University. Is that correct?
Well, Senator, I don't recall joining, but I do remember that was the issue relating to the administration that was bothering me for a period of time, including that period.
And just for the record, Mr. Chairman, I'd ask unanimous consent to insert a quotation from the Princeton packet. I'll just quote it here. Prospect editor Denise D'Souza added that CAP is concerned about the formation of a Third World Center, a campaign to eliminate the Army ROTC program, and what it perceives as the decline of Princeton athletics.
Without objection, it will be made a part of the record.
Second, on this matter, and I refer to this as the very scurrilous material read by Senator Kennedy that I suspect we would all agree was scurrilous material. Had you ever heard of any of that material that he read a while ago, before today?
No, Senator.
I believe you said you vehemently disagreed with it. Is that correct?
I do. I deplore those statements.
And would disavow it?
I disavow it. I would never associate myself with those
Did you
statements.
know that such things had been published by the PAC when you were a member of it, or when you joined
Absolutely not. I would never be a member of an organization that took those positions.
Okay, and also, Mr. Chairman, unanimous consent to, for the record, to contain the disclaimer which the editors of the Prospect include in the magazine. It reads, "The appearance of an article in Prospect does not necessarily represent an endorsement of the author's beliefs by the concerned alumni of Princeton."
Without objection, it too will be made a part of the record.
Okay, now let's return to your 15 years as a judge and how matters might come before you in the United States Supreme Court. I just wanted to also refer to something that I put in the record yesterday it is a very difficult thing to look at 4,000 cases and conclude that when you've ruled on both sides of issues, depending upon different fact situations, as we've talked about before, that you necessarily favor one side or the other. One of the areas of concern was in the area of discrimination. I just want to read one sentence of what I inserted in the record yesterday regarding employment discrimination and see if you have any other comment on it. A 2003 study of employment discrimination claims in federal court found that federal appeals court judges sided with employment discrimination plaintiffs in only 13% of the cases. Judge Alito's record of 4 out of 18, or 22%, is actually more favorable to plaintiffs. Do you know that to be incorrect, or do you have any other comment on it?
I don't know. I'm not familiar with the statistics. The way the appeal system is set up, the types of, I think that's what results in the statistics that you mentioned, that the low rate of success for plaintiffs, because these cases are generally cases in which summary judgment has been granted for the defendant. If the district court denies summary judgment for the defendant, then the case will go to trial, and very often it is settled, or there's a trial and then there's no appeal after the trial. So the cases that we get, most of the cases that we get, are cases that have been looked at by a conscientious district judge and found not to be cases that should go to trial, and I think that's what produces those statistics.
And that's an interesting lesson, I think, for all of us, to be able to explain why certain cases come to courts and why they would be more on one side than the other. And it's an important lesson, I think, both for lawyers and non-lawyers to appreciate that kind of dynamic, because otherwise, if you just look at raw statistics and don't know the background, you could come to different conclusions. So I appreciate that. Now, in another area, it is apparent to me that you're simply not going to be able to satisfy some of my colleagues because you will not absolutely commit to rule the way that they want to on a couple of key issues. For example, on the issue of abortion. You've repeatedly confirmed the significance in the role of precedent, in this case Roe versus Wade. You also noted situations in which, as a Third Circuit Court judge, you adhered to the Roe versus Wade precedent. But you have declined to announce your constitutional view of Roe today, despite repeated attempts by some of my colleagues to get you to do it in these hearings. Implied in your answer is the point that to do that here would commit you to a particular result, something you cannot ethically do. Are there cases regarding abortion that you believe may come before the United States Supreme Court?
There certainly are cases that may come before the Supreme Court. There's a case involving abortion before the court this term, and they come up with some regularity. Many of them involve the application of Roe. Most of them involve the application of Roe or the application of other precedents that build on Roe. But it is entirely possible that a case involving Roe itself could come up at some point in the future.
Now, I said in my opening statement that I would defend your right to decline to say in advance how you would rule on matters that could come before you. But kind of along the same lines that you did a moment ago, perhaps you could tell us the reason for the rule. In other words, to elaborate on the damage that would be done if judges indicate in advance how they might rule on cases. What's the reason for that rule?
To my mind, the most important reason is that to do that would undermine the entire judicial decision-making process. We have a process for deciding legal issues, and it is critically important that we stick to that process. And that means that when an issue comes before us, the briefs are not a formality. The arguments of the attorneys are not a formality. We should read those very carefully, and we should study the issue, and we should study all the authorities that are cited to us and carefully consider all of the arguments that are presented to us, both in the briefs and in the attorney's oral presentation, and then go into the conference and discuss the case among the members of the court. And we shouldn't decide legal questions without questions that are going to, not just abstract questions as if we were in a constitutional law seminar, but cases that are going to have an impact in the real world. We shouldn't decide those questions, even in our own minds, without going through that whole process. If we announced, if a judge or a judicial nominee announced before even reading the briefs or getting the case or hearing the argument what he or she thought about the ultimate legal issue, all of that would be rendered meaningless, and people would lose all of their respect for the judicial system, and with justification, because that is not the way in which members of the judiciary are supposed to go about the work of deciding cases.
I've talked about this image we have of Lady Justice, the blind figure with the scales of justice in her hand, and tried to describe why she has the blindfold across her eyes. And I just marvel at our judicial system, and having represented clients in court for 20 years myself, how we in America are willing to literally put our lives sometimes, certainly our freedom and our fortune, in the hands of a person. One judge frequently, sometimes a jury, sometimes not, sometimes more than one judge, but frequently a judge. How would people possibly have the trust to put everything they own or their own freedom in the hands of a person if we as a country hadn't established over 200 years of adhering to this rule of law, this notion that justice is blind, that the facts of your case and the law will decide whether you win or lose, and nothing else? It is a remarkable phenomenon if you stop to think about it. And not all countries do that, and even countries that have judicial systems, I don't think one can have near the confidence in that we do here in the United States. So it is a critical principle that plays itself out in courtrooms around this country every day. And it's something that I think we have to fight to preserve as much as we possibly can. And I appreciate your explanation of that. Just a couple of final things, and I'm going to be able to yield back some of my time. I just can't resist pointing out one little irony here, and it has to do with the precedent that I spoke of before, Roe versus Wade, that is so important to several members of this committee. Was written by a justice who himself was, at least in some cases, willing to throw off precedent. Do you remember who wrote the opinion in Roe versus Wade?
It's Justice Blackmun.
Justice Blackmun. And in, one might say, an infamous 1994 dissent from a denial of cert in the case of Collins versus Collins, Justice Blackmun wrote that he would refuse to follow all Supreme Court precedent on the death penalty, which has been ruled constitutional by the court, of course, by saying that he would, and I'm quoting, no longer tinker with the machinery of death, end of quote. I suspect that's not the way to deal with precedent. If you have a comment on it, fine. But again, I think it ironical that the decision perhaps most in focus here was authored by a judge who himself was quite willing to throw off precedent, I would argue in a rather cavalier way, in a situation in which he didn't like it. Let me just quote by putting something in the record and making a comment. Mr. Chairman, I ask unanimous consent to insert the following statement in the record, but I'd like to read it because it's a statement of the Majority Leader of the Senate, Bill Frist.
Without objection, it will be made a part of the record.
And let me briefly read it. As a Princeton alumnus, I had concerns about CAP, but I have no concerns about Judge Alito's credibility, integrity, and his commitment to protecting the equal rights of all Americans. Judge Alito has condemned discrimination, and his record of more than 15 years demonstrates his commitment to equal rights for women and minorities. Old documents of a now-defunct organization will not tell us more than Alito's statements and record already have. Further, the views that the Democrats attribute to Alito through CAP were the views expressed by an individual member in a magazine who was not speaking for the organization, and certainly not for Judge Alito. This is another transparent attempt by Democrats to wage an unfair smear campaign against an exceptionally qualified nominee. And Mr. President, I read that not to attribute the views to any member of this committee, but I think it's important that the reputation of this fine jurist be based upon his actions as a jurist for over 15 years, as I said in my opening statement. Longer than any other justice of the United States Supreme Court, except for one 70 years ago on a circuit court of appeals, with a record of over 4,000 decisions and an ample opportunity to know what kind of a person he is, what kind of a judge he has been, and I would argue what kind of a judge that he would make. I do not believe that his answers to questions have been inconsistent or unforthcoming. I believe that, as a matter of fact, Judge, you have been very forthcoming in your answers to questions, including getting right up to the edge on a lot of matters that arguably could come before the court. But you did not try to dodge or duck those questions at all. In fact, let me just read for the record 2 or 3 statements relating to your performance here at this hearing, if I could, please. Well, Senator Biden isn't here, so I won't read what he has said, but it's on the chart. And I appreciate what he said, by the way. Jill Zuckman, who writes for the Chicago Tribune, Judge Alito has gone farther, and I think that's given a lot more substance to these hearings, said Specter, meaning our distinguished chairman, Arlen Specter. And then Dana Milbank, writing the Washington Post, unlike John G. Roberts, Jr., who made frequent attempts to soften his views and dodged many of the questions, Alito took almost every question. Now, I'm not going to subscribe to the first part of that last quotation with respect to Judge Roberts, but I think it is true that you have taken the questions, you have answered them to the best of your ability, and you have only stopped short when not to do so would be to commit to a decision in a case that you are not ethically permitted to do and that would do injustice to the rule of law and the parties that might come before the court. So I want to commend you for being so forthcoming, for answering our questions, and for testifying in a very thoughtful and has been apparent to everybody without any notes or materials or referring to any other people here, with great knowledge about both the matters on which you have worked and the law generally. Thank you, Judge.
Thank you, Senator.
Thank you very much, Senator Kyle. Senator Cole.
Thank you very much, Mr. Chairman. Judge Alito, after the first day of questions, it seems very clear that you believe there are certain bedrock principles in American constitutional law, principles like the right of one man, one vote in redistricting, the right of children not to have to go to schools, which, unless they are integrated schools, the right for people to have privacy in making decisions about contraception and other rights. Even though these are cases where the principles are raised and their application is debated on the margins, or even more fundamentally, I believe you have said and you're willing to say that you will not question the underlying principle involved on these issues. And I commend you for that, and we are assured, and I believe that you clearly do stand by those principles. And yet when you are asked about Roe versus Wade and the following case of Casey, cases that say the government should not place an undue burden on a woman's right to choose, when we ask about principles of that sort, you are unwilling to make the same statement of support. Now, I understand that there will be cases where plaintiffs argue about on the margins about Roe and Casey, where there are efforts to narrow or broaden these principles, just as there are cases that narrow or broaden the principles of one man, one vote, or Brown versus the issue enunciated in Brown versus Board of Education, or Griswold. But you are willing to stand by those other legal principles, and yet you're not taking the same position with regard to the principles embodied in Roe and Casey. Could you explain that, please?
Senator, I think it's important to draw a distinction between issues that could realistically come up before the courts and issues that are still very much in play, which is to say the subject of litigation in the courts. And I felt comfortable about commenting on one person, one vote, and of course Brown versus Board of Education, because those are not issues that are any longer the subject of litigation in our country, not the fundamental principles that are embodied in those decisions. And the Griswold case likewise concerns an issue that is not realistically likely to come before the courts. Roe, on the other hand, involves an issue that is involved in a considerable amount of litigation before the courts. And so that's where I feel that I must draw the line, because on issues that could realistically come up, it would be improper for me to express a view, and I would not reach a conclusion regarding any issue like that before going through the whole judicial process that I described.
I think there's strength to what you say, but I also believe it's not inaccurate to say that these other issues on the margins, just as Roe on the margins, are still coming up and may yet come up before the court. And I still feel that you are, while you are prepared to take a position on these other issues, which is in almost bottom line, clearly bottom line, you're not prepared to take that same position, which you could if you wished. You could take that position if you wished. And I think what that does suggest is that what you are saying is that it is possible, if a case comes before you, that you would take a look at the principles underlying Roe and Casey and see them in a way that would overturn Roe and Casey. Now, you may say, well, obviously the answer is yes, but I just want to get that clarified for the record.
Well, what I would do if a case like that were to come before me, and if I'm confirmed, is to follow the two-step process that I've talked about, which is first to consider the issue of stare decisis. And there's been a considerable body of case law now on this issue going back to Roe, and in particular over the last 20 years. And in the Casey opinion, that was where the joint opinion began and where the joint opinion ended. And then only if I got beyond that issue would I consider the underlying issue. And that's what I would do if the issue were to come up. And I don't believe that it would be appropriate, and it wouldn't even be realistic for me to go further than that.
That is correct. And in your mind, you're not prepared to say that the principle embodied in Roe and Wade, or the principle embodied in Casey, is clearly established law. That is not subject, in your mind, to review.
Well,
You're not prepared. I mean, that is not your position, which I think you have said. But I think, at least for me, a clarification of that would be of some importance.
Well, in light of the current state of litigation relating to the issue of abortion, and as I said, there's an abortion case before the Supreme Court this term, and there are undoubtedly abortion cases before the lower federal courts. I know there are. I don't believe that it's appropriate for me to go further than that in relation to that issue.
All right, Judge Alito, President nominated you for the Supreme Court because of your record as a person and as a judge. Groups and individuals, particularly on the right, quickly endorsed you soon after your nomination because they feel comfortable with your record, as you have established it over several decades now, where you've come from, and where you are on the issues that are important to them. We also assume that you yourself are very proud of your record, as you should be. As a man of principle and conviction, which we believe you are, you worked on issues throughout your career as a Justice Department attorney that you believed in, that you cared about, that mattered to you. And I'm certain you would say that if you didn't believe in these things, you would not have gone to work for that particular Justice Department under that particular administration. And yet yesterday, during the hearing, you seemed to walk away from a lot of your record. For example, when asked about an interview where you supported Judge Bork, calling him, quote, one of the most outstanding nominees of this century, you answered that you were just supporting the administration's position. That wasn't your position.
I think this is going to keep coming back.
And even then, you distanced yourself from a number of his views, after having said that he was one of the most outstanding nominees of this century. You are a man of conviction. I'm sure you are. And you're not just a mouthpiece for people. You never have been, and you never will be, which is to your credit. When asked about the strong position you took opposing a woman's right to choose in your job application, you said that only reflected how you felt then and did not suggest anything of what you believe now. What you felt then, you felt as a full-grown man. And you're saying that's not how you necessarily feel now. When asked about your membership in a radical organization at Princeton, a group that you cited with pride on your job application, you said that you could not remember anything about the group at all. When asked about the citation in your job application where you referred to the importance of traditional values and what you meant by traditional values, and then you answered somewhat incomprehensively when you said that you were protecting children from, quote, psychological threats that come from elements in the atmosphere is a traditional value, unquote. I also asked you about your statement on your job application that you disagreed with the Warren Court's rulings on reapportionment, rulings that stand for the basic principle of one person, one vote. Indeed, you said your disagreement was so strong that it contributed to your decision to pursue a legal career. Yesterday, you stated that you, in fact, did not disagree with the principle of one person, one vote, not then, not now. So, Judge, this is the only time that the people of this country are going to have an opportunity to get a sense of who you are, what you believe in, what you stand for, who you are as a person. I think you would say that the American people have the absolute right to know that, without condition, without any political considerations, that the most important part of this hearing is that the American people get a chance through our questions and your answers to know who you really are. I would like to hope that you would say the job isn't worth it if we can't do that and do that well. And I believe you believe that. So I would like to ask you how you bring into a sense of harmony some of these things that you have done and said throughout your career, which have brought you to this situation in which you are now a person being nominated to serve on the Supreme Court, and some of the positions that you've taken in the last 2 days, which in effect distance you from some of the very things that you have done and stood for over a career that bring you to where you are today.
Senator, you mentioned a number of things, and I tried to jot them down so that I could cover at least the major things that you mentioned. You mentioned, and I guess I'll take these in reverse order of chronology, you mentioned the statement in the 1985 statement relating to reapportionment. And I've tried to explain what I had in mind. The statement in the 85 statement talked about what I thought about reapportionment when I was in college. And the reason why I mentioned that, why would I mention what I thought about constitutional law in college before I had even been to law school? What I was attempting to do was to explain the development of my thinking about the role of the judiciary and about constitutional law, and in particular, the development of my strong belief in judicial self-restraint. And the first place in which I saw a theoretical explanation of that doctrine, which I found persuasive at the time, was Alexander Bickle's book, The Supreme Court and the Idea of Progress, which came out during the time when I was in college. I think it was the first book about constitutional theory, so to speak, that I had read. And he addressed the issue of one person, one vote. And that linked up in my mind with the experiences of my father in working on the reapportionment of the New Jersey legislature. And at the time when I was in college, there was an issue that was very much a live issue at the time as to what one person, one vote meant. Did it mean that you took this principle of one person, one vote and applied it with blinding literalness so that every district was exactly equal in population or very close to that with a population deviation of under 1%, or could other factors that people thought were legitimate factors to be considered in drawing districts, such as respecting county lines and municipal lines, was it permissible to take those into account? And that's what I know I was thinking about reapportionment back in my college days. I referred in the statement to traditional values, and I said yesterday, at this point in 2006, I can't say for sure exactly what was on my mind in 1985 when I made reference to traditional values, but I tried to describe some of the things that I probably thought were thought of as traditional values, and I listed a number of them. One, and a lot of them had to do with the ability of people to live and raise a family in the sort of neighborhood where I grew up, and I gave a little description of that earlier. So it would include things like being able to live in peace and safety. I think that's a traditional value, and that was very much at stake when I was in college in the late 60s and early 70s and in 1985, because these were eras of high crime, and a lot of the work that I had done up to 1985 as an assistant U.S. attorney and working on criminal cases in the Solicitor General's office seemed to me to be involved with this issue of protecting people from the threat of crime. I think I mentioned the ability to raise children the way you want, to instill your values, not to have them subject to certain external threats. And these were, I've tried to think of why would these have been at issue in the mid-'80s, and they were at issue because of things like some of the things I was referring to earlier today about children being able to, and students being able to express their religious views at school, if in a non-discriminatory way, so that religious speech was not discriminated against. And that was very much at issue in the 80s. The Congress passed the Equal Access Act at about that time to embody that principle. So those were some of the things that came to my mind as traditional values. The 1985 statement in reference to abortion, I have not distanced myself from it. I have said that that was a correct expression of what I thought in 1985 when I wrote it. It was written in 1985, and that was 20 years ago, and there's been a lot of case law in the intervening years. There was Thornburg, and there was Webster, and Casey, all of which involved direct challenges to Roe, and there were other cases applying Roe. So that's what I had in mind with respect to the matters that you've covered.
Last question. When we met privately, I asked you what sort of Supreme Court justice you would make, and your answer was fair when you said, if you want to know what sort of justice I would make, look at the sort of a judge that I have been. Last week, the Washington Post did exactly that in an analysis of your record as a Third Circuit judge for the past 15 years. They analyzed 221 cases that you sat on in which the court's decision was divided. I recognize that in every case there is a difference, and they must be decided on its facts. Nonetheless, this data reveals patterns and tendencies in your decisions, among other things, as you may have recollected from the Post article. It was found that in civil rights cases you cited against 3 out of every 4 people who claimed to have been victims of discrimination. This was a significantly greater rate than other judges in a national sample of cases. Of 33 criminal cases a newspaper analyzed, you sided with the criminal defendant only 3 times. This was a very much lower rate than the national sample. In immigration cases, the Post also found that you sided with immigrants who were trying to win asylum or block deportation. Only in 1 out of 8 cases analyzed. This was much less than most judges in the national sample. Now, the Washington Post was not the only one to perform an analysis of your record. Noted constitutional law professor Cass Sunstein, for example, found that, quote, when there is a conflict between institutions and individual rights, Judge Alito's dissenting opinions argue against individual rights 84% of the time. So what can we glean from these analyses, Judge Alito, and what might they indicate with respect to your posture on cases should you become a justice of the Supreme Court?
On the discrimination cases, Senator, I think that the statistic that Senator Kyle just cited speaks directly to that, a comparison of the number of times in which people claiming discrimination prevailed in the cases, won my vote, and compared to the average for circuit judges in general. And I think that those statistics, my statistics and the statistics for circuit judges in general, have to be viewed against the background of, have to be viewed with a recognition of the way in which these discrimination cases come up through the court system. Most of them are cases in which the person claiming the violation lost in the district court. And that means that a district court judge, and they're not always right, but most of the time they're right, and they're conscientious people, and they apply the same law that we do. They found that these were not meritorious cases. And so if you start out with a group of cases that have already been found to be not meritorious, it stands to reason that probably not a very high percentage of them will ultimately be found to be meritorious. On the immigration cases, I take very seriously, and I don't know what the statistics are in this area, but I can tell you this, that I take very seriously the scope of review that I am supposed to perform as an appellate judge. And that is usually dictated by Congress. And in the area of immigration, Congress has spoken clearly. And as to factual decisions that are made by an immigration judge, what Congress has told us is you are not to disturb those unless no reasonable fact finder could have reached the conclusion that the immigration judge did. And I very often see a record where I think it's doubtful. I say to myself, I might have decided this differently if I were the immigration judge, but I wasn't there. I didn't see the witnesses testify personally, and Congress has told me what my role is there. My role is not to substitute my judgment for that of the immigration judge. My job is to say, could a reasonable person have reached the conclusion that the immigration judge did? And if I find that a reasonable person could have reached that conclusion, then it's my job to deny the petition for review, and that's what I do in those instances.
I appreciate that. I would just comment again that your siding with immigrants who are trying to win asylum or block deportation, you cited only in 1 out of 8 cases that they analyzed, and this was much less than most judges in the national sample who were about evenly divided in their decisions on these issues. This was what their analysis indicated. So, you know, that for whatever it's worth, you were 1 out of 8, and national sample of judges was about 50%. I only bring that up for your comment. I thank you very much, Judge Alito, and Mr. Chairman, I thank you.
Thank you, Senator Gould. We have made some inquiries about the issue which Senator Kennedy has raised about the Concerned Alumni of Princeton. As to the letter, I'm advised by my Chief of Staff, Michael O'Neill, that he first saw a computer letter and that he believes later a letter was delivered to the Judiciary Committee headquarters, apparently on near Christmas, perhaps on Christmas Eve. And our custom is to log letters in, and the letter was never logged in. But I repeat and confirm that I've never seen this letter until I saw a computer printout of it about an hour ago. Mr. O'Neill did talk to me about it over the break between Christmas and New Year's. I traveled to Iraq. That's the first time on the Judiciary Committee schedule I could find a few days to get away. And Mr. O'Neill reminds me that we talked about it on the phone, and I thought the matter was unmeritorious, not worthy of the time of the commission, based on all that that I knew about it. Very brief conversation. And we get so many requests, and there are so many items that are largely staff-driven, not that staff-driven matters aren't important, but if something is of significance, you customarily expect a member to tell you about it. Senator Kennedy and I frequent the gym at the same time and talk all the time, and never mention it to me, nor did he take it to the ranking member. I make it a point that Senator Leahy's calls are the first ones I return, and I have a fair number. But I return all calls from members very, very promptly. And had this matter been presented to me, I would have given it more attention than I did on that telephone call that I have referred to. So much for matters which are not quite as relevant as what I'm about to come to. The New York Times published a story about this on November 26th, and my Chief of Staff, William Reynolds, talked to David Kirkpatrick, who said he had gone through all of the records, and as the story in the public domain stated, these are the records at the Library of Congress, the Russia records. Those records and others at the Med Library at Princeton give no indication that Judge Alito was among the group's major donors. He was not an active leader of the group, and two of his classmates who were involved, and Mr. Rusher said they did not remember his playing a role. The obvious thing to do is to call Mr. Rusher, which Mr. O'Neill did over the lunch hour. And Mr. Rusher said he'd be glad to have us look at his records. And that he received a request from Congressional Research Service, but it was from an unnamed requester, and he declined. But he said had he received a request from Senator Kennedy or some member of this committee, he would have made the records available. So in Senator Kennedy's absence, I asked a staffer to tell him that we had moved ahead, but I didn't want to waste any time. And Mr. O'Neill has contacted Senator Kennedy's staffers, and they're en route or at the Library of Congress to look at these records so that we can confirm what the New York Times' David Kirkpatrick has had to say. I'm just a little puzzled at the issue being raised in this manner. We talk all the time, and I'm just a little surprised that Senator Kennedy hadn't talked to Senator Leahy or hadn't talked to me before he made a request for access to the Russia records, talks about a subpoena, talks about a ruling of the chair, talks about overruling the chair. Just a little puzzled, but the substantive matters are being attended to. And I share Senator Kennedy's concern that we have all the facts. And this is a lifetime appointment. It's a matter of tremendous importance. And I wouldn't want to find on some occasion that something comes to light which would bear on this nomination that we could have found out had we been more vigilant. Senator Kennedy?
Thank you, Mr. Chairman. I welcome the fact that we're going to have the access to those records. The fact remains, I didn't anticipate. I thought that since this was a major issue on the 1985 application of the nominee for a new job, this membership with the Federalist Society and the CAPA organization. I thought as a matter of routine that we'd have access to those records. And it was a letter to you, as we would do, and would follow up with the staff, which is a usual procedure here. I regret I haven't been down in the gym since before Christmas, so I've missed you down there. But the important fact is we're going to get that information. I think that's what's extremely important. And quite frankly, if we had been able to get what I think were more responsive answers by the nominee during the course of the exchange today, I don't think probably it would have even been necessary. But I don't think you'll be able to look through the transcript of the exchanges that we had with the nominee and not feel that they would have an important responsibility to follow up. So I'm grateful that we will have that chance to follow up and look forward to the further considerations of evaluation of the material and further considerations of the hearing.
Enough said.
Chairman,
Senator Leahy, you have a unanimous consent
Yes,
request.
Mr. Chairman, as I had understood, we'll be going back to this another round, so if I misunderstood you, sure, correct me, but as I understood Judge Alito, he saw no connection between his unified executive theory and the use of presidential signing statements. In fact, the Wall Street Journal reported the president has cited the unitary executive 103 times in presidential signing statements. So I'd like to put that article, some articles from the Post and the Globe relevant. And in fact, the defense bill, the McCain torture amendment, he specifically employed. I'd like to make that part of the record.
Without objection, those documents will be made a part of the record. Senator DeWine.
Thank you,
20
Mr.
minutes.
Chairman. Judge, yesterday you and I discussed the concerns that I have about the Supreme Court's willingness to strike down laws passed by this Congress and by state legislators. This lack of what I consider to be appropriate deference by the court endangers our ability to protect the rights of our citizens. One of the groups that I'm most concerned about in that context is people with disabilities. Congress has passed a number of laws to assure that people with disabilities have equal access and equal opportunities. I think it's critically important that we make sure that those with disabilities have these opportunities to participate fully in our society in every way possible. As you know, Judge, the Americans with Disabilities Act was a landmark piece of legislation passed by this Congress in our ongoing efforts to assure that people with disabilities are treated fairly. The 1999 case of Olmstead versus LC was an important Supreme Court case interpreting this law. As you know, Olmstead held that Title II of the ADA requires states to serve individuals with disabilities in community settings whenever possible, instead of segregating them while providing them with care. Olmstead was decided after the case of Helen L. versus D. Dario, case which, of course, you're familiar with, a Third Circuit case that reached essentially the same conclusion. Although you were not on the Helen L. panel, you, along with 4 other judges, voted to rehear the case en banc. So let me ask you, Judge, if you could, to discuss with us your reasoning behind voting to rehear the Helen L. case. I'd like to ask you, did that vote to rehear the case mean that you thought that Helen L. case was decided incorrectly, or that you opposed the later holding in Olmstead? And let me also ask you that now that Olmstead has been decided, do your reasons for voting to rehear the Helen L. case still apply? And do you have any concerns with the Supreme Court's holding in Olmstead that would cause you to question the validity of that particular decision?
I certainly don't have any concerns about the decision in Olmstead. I would have to look at my own file in the Helen L. case, and I doubt that there is any file in the case at this point, to try to and see if there's anything in there to indicate specifically why I voted for rehearing in the case. And perhaps but I can say this, that I read the decision again, and one important part of the opinion in the case attempts to distinguish an earlier Third Circuit case that seemed to be somewhat closely related to the issue that was at hand. And I noted there were 5 votes for rehearing in the case, and that's quite unusual. It's unusual for there to be that many votes for rehearing. Most of the time, I would say most of the time when we vote for rehearing, the reason is because we think that there may be an inconsistency in our court case law, and that doesn't necessarily mean that we think that the decision we're voting to rehear was incorrect. Quite often, we think the decision that we're voting to reconsider is correct, but that it is inconsistent with a prior case that needs to be overruled, and we're very scrupulous about following our own precedents, not ignoring them. So if we have a precedent out there and it seems to us to be wrong and the issue comes up in a later case, then our mechanism is to vote to rehear. And that happens very often. And my guess, based on what I can tell just from reading the opinion and looking at the votes for rehearing and the judges who voted for rehearing, that could have been what was going on.
I appreciate your answer, Judge. As the chair of this subcommittee on antitrust, I have seen that it is very often very hard to draw the line between anti-competitive conduct and frankly, just good old-fashioned competition. Let me give you an example that Senator Cole and I have done a great deal of work on, and frankly, Senator Cole has really taken the lead on. Many hospitals buy their supplies through group purchasing organizations known as GPOs. These organizations purchase products for a large number of hospitals at one time, which decreases prices, but also gives them extraordinary power over which products get used and which ones don't get used. Often GPOs reach deals with major suppliers to buy items in bundles. In other words, buy a number of different products from those suppliers in order to get discounts on all of the products. Saves money, but it also means that smaller companies, which may only offer one of these products, have really a hard time competing with the large discounts being offered. The result is that smaller companies have difficulty getting into the market, even if their one specific product may be better or may even be cheaper. Judge, you had a case that dealt with bundling like this. It was, of course, the 3M versus LePage case. In that case, 3M, which sells Scotch tape, was selling it as part of a bundle with other products. The result was that LePage's, which was offering a cheaper competing tape, was having a hard time getting stores to sell its tape. Because if the stores they would have to give up the chance to save money on all the other 3M products that they carry. The majority ruled against 3M, but you dissented. And I wonder if you could please explain your reasoning behind that dissent and explain what type of bundle discounts you think would violate the antitrust laws.
Well, let me preface what I'm going to say by saying that I'm not an antitrust expert. And so I plod my way through these antitrust issues when they come up. But this was a tough one, and it was a monopolization case, and it required an examination of all the factors that were relevant to determination of whether 3M was engaging in monopolization. 3M was selling the product, as I recall. It was selling these products. It was not selling them below its cost. It was selling them above its cost. But 3M was, because of its scale or because it was more efficient, was able to produce its product more cheaply. And I remember looking at the authorities that had discussed this and the writing of leading antitrust experts on bundling issues, and that factor, taken together with the other factors in the case, persuaded Judge Greenberg and I, and we were the majority on the case at the panel level, that there wasn't sufficient evidence of monopolization here. And then when the case went on bank, the court as a whole came out the other way. But my understanding of the state of the scholarship on this issue right now and on the way economists view the issue is that I believe that there are many of them who believe that this is a situation like this does not involve monopolization, that this is not a way in which a company like that can engage in a predatory practice over a period of time. But there's uncertainty really about how the monopolization standard applies to issues of bundling. So I think it's quite up in the air. And should it come up again, I think it merits re-examination.
Thank you, Judge. Judge, you've heard a lot of discussion, and many of us have said that we don't like it when judges legislate from the bench. For judges to properly perform their function, obviously it's crucial that they attempt to put their own policy preferences aside in the cases before them. But it seems to me that this is a lot easier said than done. Our Constitution is not a dictionary. It contains a number of very broad, undefined phrases. Let me give you some examples. Fourth Amendment prohibits unreasonable searches and seizures. The 14th Amendment says that the state shall not deprive any person of liberty without due process of law. The 8th Amendment prohibits cruel and unusual punishments, and I'm sure you could supply a lot more examples than I am. When confronted with such broad phrases like unreasonable, liberty, cruel, unusual, How do you know whether you're making policy or merely interpreting the Constitution itself? And what tools will you use as a Supreme Court justice to ensure that your personal views do not play a role in your decision-making?
In all the areas that you mentioned, there is now a considerable body of case law, and that is a real limitation on the exercise of judicial power. And that is one of the important reasons for the doctrine of stare decisis. In the 78th Federalist paper, when Alexander Hamilton was responding to the people who were worried about this power of judicial review, who thought that it would give the judiciary too much power, he specifically cited the fact that members of the judiciary would be bound up by precedent, and this would restrain them. This would keep them from injecting their own views into the decision-making process. Under the Fourth Amendment, there's an enormous body of case law now, and there are many types of searches that it's established in case law that a warrant is required. There are types of searches where it's established now that the activity can be conducted with reasonable suspicion. A Terry stop, for example. Other types of searches require probable cause. And there are many specialized types of searches, administrative searches, roadblocks constructed for certain purposes, border searches, and so forth. Under the due process clause of the Fifth Amendment and the 14th Amendment, there's a great body of case law on procedural due process, and most of the due process issues involve procedural due process, what sort of process is required. There is a standard for cases involving the substantive component of that. Under the Eighth Amendment, since the Supreme Court in Gregg versus Georgia ruled that the death penalty is permissible under certain circumstances, there's a large body and a complex body of case law within which a judge would work in deciding cases in that field.
Judge, let me turn to an area that I talked with Judge Roberts about, and that is free speech in the public square. To me, there's perhaps no right in our Constitution that is really as important as the freedom of speech. The heart of the First Amendment is the idea that people have a right to speak their mind, but also be heard on matters of public concern. Traditionally, our citizens have expressed their opinion on public issues by turning to the public square. They do it in parks, and streets, sidewalks, anywhere that people gather. It's as old as the country and older than our country. Lately, however, I believe that we're seeing a disturbing trend. In many cases, governments have sought to restrict speech in the public arena, sometimes with success, sometimes without. Let me give you some examples. One recent case, a Wisconsin woman was kicked off a city bus when she tried to distribute a book containing Bible stories to individuals sitting next to her. In many towns and cities across the country, individuals are prohibited from placing political signs on their own property. They're told what size they can put out, they're told the times they can put it out, the dates they can put it out, etc. And in many public places, individuals have been forced to hold up signs or protest and been confined to free speech zones far away from the event that they wish to protest. These individuals doing nothing more many times than just standing there with a sign. These sorts of restrictions concern me because they limit the ability of individuals not only to speak but also to be heard in public places. People who want to talk about politics, religion, or any other matter of public concern. I think we need to be careful as a society before we limit what people can say and where they can say it. Let me ask you, how do you approach challenges to government restrictions on the ability of individuals to speak and be heard in public places? And what judge factors do you consider when deciding which restrictions on speech in the public square are proper under the First Amendment and which ones are not?
I think that that freedom of speech and freedom of the press and all the freedoms set out in the First Amendment are matters of the utmost importance. Freedom of speech is not only important for its own sake, but it is vital to the preservation of our form of government, and I think that if anybody reviews the opinions that I've written in the area of freedom of expression and other First Amendment
I've
freedoms,
looked at some of them at least.
they will see that I strongly support those rights. The issue of speech in particular places is a daunting issue. The Supreme Court has addressed it by developing the forum doctrine, and they have identified what they call a public forum, which would be something like a public street where people's ability to speak is at the maximum. At the other extreme, there's a private forum. My chambers would be a private forum. A senator's office would be a private forum. Someone from would not have a right to come in from the street and speak in a place like that. And then there are what they call limited public forums or dedicated public forums, or for places where people can speak freely, but only at particular times on particular subjects. A place that's dedicated to free speech, but only on a particular subject, for example. That's the way they analyze it. Now, there's some people would say that there are developments in society that have resulted in the shrinking of public fora that make it more difficult for people to express themselves. I know that I'm not up to date on New Jersey case law under the New Jersey Constitution, but it's my belief that our state has a different forum doctrine in things like shopping centers, malls that are privately owned are considered to be public fora under a New Jersey state law. I think some other states view it that way, and that's a competing way of looking at this problem. An important principle where I have dealt with this in my cases, as I can recall, is the issue of freedom of speech in a limited public forum. And even in a limited public forum, what government cannot do is engage in viewpoint discrimination. If the government opens up a particular forum for discussion of a particular subject, it can't say, but we're only going to allow people who express this viewpoint and not another viewpoint. Viewpoint discrimination really goes to the heart of what the First Amendment is intended to prohibit, so that even in a limited public forum where people are restricted with respect to what the subject that they can talk about, government can't impose a viewpoint discrimination.
Well, it just seems to me, Judge, that we could talk about this issue all day, and we're not going to, obviously, but that there is a shrinking public forum, and the opportunities many times are going away. I guess you could make the other argument that because of modern technology, there are other opportunities with the internet, et cetera, that they're opening up for people to communicate and to make their point well known. But a lot of the places that people historically have talked and made their point well known are shrinking. You talked about the malls, which are certainly in most states are totally off limits to any kind of display of that kind of debate. Let me turn to commercial speech, if I could. Under current law, commercial speech is protected by the First Amendment, but it has never had the same level of protection as other forms of speech, such as political speech. The difference in treatment has puzzled a number of commentators and judges. In reviewing your cases, I noticed that you are certainly familiar with the issue of commercial speech. In Pitt News case, for instance, you struck down a Pennsylvania statute that barred paid alcohol advertisements in newspapers affiliated with colleges and universities. Let me ask you, Judge, based on your experience with this and other cases, what is your view about the distinction between commercial speech and non-commercial speech? And is there a common sense difference between these two types of speeches? And have you found that case law supports any distinction? And how, if confirmed, will you approach the so-called commercial speech claims under the First Amendment?
Well, there's a debate about how much protection commercial speech should have. There are those who argue that the distinction between commercial speech and non-commercial speech should be eliminated. The Supreme Court views commercial speech differently, and while it is strict about any limitation of regarding accurate information about prices. It permits greater restriction of commercial speech under current case law than it does with respect to other types of speech. And the theory, as I understand it, is that commercial speech is more durable. At least that's part of the theory. In other words, there's such a great incentive for people who are selling things to engage in advertising and other forms of commercial speech that it's less likely to be driven out than speech on other issues where the financing may not be as extensive. In the Pitt News case, what I had to apply was the question of whether there was sufficient tailoring. There was a compelling interest for what was done there, which was to restrict advertising about alcohol in a publication that was affiliated with an educational institution. But based on the facts there, it just did not seem to be tailored at all. This was a newspaper that I think 75% of the people who received it, and it's connected with the University of Pittsburgh, were people over the drinking age. And maybe even more to the point, this publication was distributed free on campus in newspaper boxes next to a number of others that contained commercial publications, and they both advertised establishments and events in the area of the university, and the others were full of information about alcoholic beverages, and those were free too. So while the problem of underage drinking and abusive drinking on college campuses is a very serious issue, and the Pennsylvania legislature recognized that, and we certainly didn't question that, that it is an issue of critical importance. It seemed quite unrealistic to think that this regulation, which only applied to the Pitt News and not to these other publications, was tailored sufficiently.
I thank you, Judge. Interesting set of facts. I thank you, sir.
Thank you, Senator DeWine. Senator Feinstein.
Thank you very much, Mr. Chairman. I want to try one more time. First of all, let me just say this. Senator Dermott said that Justice Roberts retired the trophy on performance. If that's true, you've retired it on equanimity. I really think you're to be congratulated. This is this morning's Washington Post. Alito says he will keep an open mind. But what concerns me, and obviously this is on Roe, is that despite 38 tests, despite 33 years, despite the support of a majority of America, you also said yesterday that precedent is not an exorable command. And those are the words that Justice Rehnquist used, arguing for the overturning of Roe. So my question is, did you mean it that way?
The statement that precedent is not an inexorable command is a statement that has been in the Supreme Court case law for a long period of time. And sitting here, I can't remember what the origin of it is, but I would bet that it certainly has been used in cases in which the court has invoked the doctrine of stare decisis and refused to go ahead and overrule.
I always believe everything I read in the Washington Post.
Well, that is an important principle, and not the principle of believing everything in the Washington Post, but the principle that stare decisis is not an inexorable command, because then we would be stuck with decisions like Plessy, and they couldn't be overruled except through a constitutional amendment. But when an issue is one that could realistically come up, the people who would be making the arguments on both sides of the issue have a right to have a judiciary of people with open minds, and that means people who haven't announced in advance what they think about the issue, and more importantly, people who are not going to reach a conclusion until they have gone through the judicial process. And it's not a facade. It's not a meaningless exercise. It's a very important one.
Let me try this. I'd like to read a line of questions that Senator Specter asked now Chief Justice Roberts. And then I'd like to ask this question. How do you disagree with this? Here's the question. Specter, Judge Roberts, in your confirmation hearing for the Circuit Court, Your testimony read to this effect, and it's been widely quoted. Quote, Roe is the settled law of the land, end quote. Do you mean settled for you, settled only for your capacity as a circuit judge, or settled beyond that? Roberts, well, beyond that. It's settled as a precedent of the court, entitled to respect under principles of stare decisis. And those principles, applied in the Casey case, explain when cases should be revisited and when they should not. And it is settled as a precedent of the court, yes. Specter, you went on to say then, quote, it's a little more than settled. It was reaffirmed in the face of a challenge that it should be overruled in the Casey decision. So it has added precedential value. Roberts, I think the initial question for the judge confronting an issue in this area, you don't go straight to the Roe decision. You begin with Casey, which modified the Roe framework and reaffirmed its central holding. And Specter says, and you went on to say accordingly, it's the settled law of the land, using the term settled again. And then your final statement as to this quotation, there is nothing in my personal views that would prevent me from fully and faithfully applying the precedent as well as Casey. Where do you differ, since Justice Roberts made that statement in a confirmation hearing? He not only got confirmed he's the Chief Justice, it seems to me appropriate for you to comment on it and say where you might differ with it.
Well, the statement covers a lot of ground, and let me try to remember the major points. I certainly agree with the point.
I can give it to you if you'd like. Would that be helpful?
I'd be happy to.
Could someone take it down to him? Show him the place.
Now famous.
Yeah.
Be on the front page tomorrow.
Well, Senator, I certainly agree with the point that the Chief Justice made about separating any personal views he has from anything that he would do as a member of the Supreme Court. I emphatically agree with that. That's the essence of what a judge has to do. I certainly agree that Roe and Casey and all of the other decisions in this line are precedents of the Supreme Court, and they are entitled to respect under the doctrine of stare decisis. To the extent that some of the earlier decisions have been modified, then obviously the most recent ones are the relevant provisions of the Supreme Court. I've agreed, I think, numerous times during these hearings that when a decision is reaffirmed, that strengthens its value as stare decisis. I agree that when the Supreme Court entertains a challenge to a prior decision and says we're not getting to a reexamination of the merits of the issue, we think stare decisis counsels against our going to that point, then that is a precedent on precedent. That seems to me to be entirely logical. And there we have a long line of precedents now relating to this issue. I've said, I think, I have said that stare decisis is a very important legal doctrine, and that there is a general presumption that decisions of the court will not be overruled. There needs to be a special justification for doing it, but it is not an inexorable command.
But you do not agree that it is well settled in the court?
I think that depends on what one means by the term well settled.
I actually agree with you, because others have said that and then gone out and voted to overthrow it.
Well,
so
let
it's
me
like
just
I
say-
have no quarrel with
Just say
that.
this, as a judge on the Court of Appeals, or if I'm confirmed as a justice on the Supreme Court, it would be wrong for me to say to anybody who might be bringing any case before my court, if you bring your case before my court, I'm not even going to listen to you. I've made up my mind on this issue. I'm not going to read your brief. I'm not going to listen to your argument. I'm not going to discuss the issue with my colleagues. Go away. I've made up my mind. That's the antithesis of what the courts are supposed to do. And if that's what settled means, then I think that's That's not what judges are supposed to do.
But let me interrupt you for a moment, if I may. You were willing to give your view on one man, one vote. And yet there are 4 cases pending in the court right now on one man, one vote. And that's where I have a hard time. The cases are Lulac v. Perry, Travis County v. Perry, Jackson v. Perry, and G.I. Forum of Texas v. Perry. That's where I have a hard time. If you're willing to say that you believe one man, one vote is well settled, and you agree with it, I have a hard time understanding how you separate out Roe. I understand why. If you say one thing, you upset my friends and colleagues on that side. If you say the other, you accept those of us on this side. But the people are entitled to know.
I don't think it's appropriate for me to speak about issues that could realistically come up. And my view about Brown versus Board of Education, for example, which was one of the cases that was cited in connection with this issue about where someone in my position should draw the line, seems to me to embody a principle that is now not subject to challenge, not realistically subject to being challenged, not within the legitimate scope of constitutional debate any longer, that there should be segregated racial facilities that are segregated on the basis of race. And that's where I've tried to draw the line. If an issue involves something that is in litigation, then I think it's not appropriate for me to go further than to say that I would be very respectful of the doctrine of stare decisis, and I would not reach a decision on the underlying issue if one were to get to it without going through the whole decision-making process.
Okay, I'll let you off the hook on that one. One of the reasons that some of us are so concerned about the Commerce Clause is because we see major law being overturned if the Rehnquist Court continues its march. Let me give you an example in the environment, and these are cases that will be before you, so I don't expect you to comment on the case, but to understand. The Clean Water Act was passed in 1972, and it included a provision permitting citizens or citizen groups to bring lawsuits for violation of the act. In Public Interest Research Group of New Jersey versus Magnesium Electron, a citizens' environmental group sued a chemical manufacturer under the Clean Water Act for polluting a river used by members of the group. The trial court found that the defendant committed 150 Clean Water Act violations. On appeal, you were the decisive vote in a 2-to-1 decision overturning the trial court's decision, even though it was undisputed that the defendant committed the 150 violations of the Clean Water Act. Your decision, as I understand it, was based upon your conclusion that the environmental group did not have standing to sue under the Clean Water Act, because even though members of the environmental group had stopped using the river due to the pollution, they did not prove any injury to the environment. The decision, if broadly applied, would have gutted the citizen lawsuit provision of the Clean Water Act. Now, 3 years later, in Friends of the Earth v. Laidlaw, the Supreme Court, in a 7-to-2 decision, rejected this reasoning and held that a citizen only needed to show that he or she was harmed by the Clean Water Act violation and didn't need to prove a broader injury to the environment. So you see where the concern comes with respect to overthrowing something on a technicality that can have enormous implications. Do you agree with the Supreme Court's decision in Friends of the Earth v. Laidlaw?
Well, it's a precedent of the court, and I have respect for it, and as you mentioned, and it's governed by stare decisis, and as you mentioned, it was decided after the decision of my court in the Magnesium Electron case, and I haven't gone back and thought about the question of whether Laidlaw creates doubt about the soundness of the decision in Magnesium Electron. If it does, then than it does. And if the issue were to come up again before the Third Circuit, for example, and I sat on the issue, then I would follow Supreme Court precedent if I concluded that it was in conflict with the decision of a prior Court of Appeals decision. We have our jurisdiction under the Constitution is limited to cases and controversies. The Supreme Court has said that means you have to have a plaintiff who has suffered injury in fact. And although there was a disagreement on the panel about the procedure we should use going forward, everybody on the panel agreed, Judge Roth and I, who were in the majority, and Judge Lewis, who dissented on a procedural point that I'll get to, that the plaintiffs in that case had not even alleged personal injury. They alleged that they enjoyed the Delaware River in a variety of ways. As I recall, they walked along the canal path, they ate fish from the river, they drank water from the river, but there was no evidence that the discharges into a creek some distance upstream from the river had had any effect whatsoever on the river, and therefore there was nothing to support a claim that they were personally injured by the discharges of this plant. Now, there would presumably be other people who could take legal action against the plant for its violations of the law, and nobody would condone that. But our obligation under Article 3 is to confine ourselves to cases within our constitutional jurisdiction.
Of course, you're going to have two cases challenging the application of the Clean Water Act to non-navigable waters under the Commerce Clause. And as you probably know, we have lost 90% of the wetlands in the United States. This is a very big deal. And, I mean, there are many of us that would hate to see wetlands be made virtually impossible, because it's very difficult to prove when something becomes navigable as opposed to non-navigable, which is kind of the question that's before the court. I only say that because if this march to restrict Congress, you could strike down the Endangered Species Act, you could strike down the Clean Water Act, you could strike down the Clean Air Act, and I think that would be catastrophic for the United States. If I can, let me just switch to another topic. And a year ago, all of us became very concerned and involved, and some horrified, with the Terry Schiavo case. And as I recall the case, the local courts held that her life support could be turned off. The state Supreme Court held the same thing. And then there was an effort, and I think a federal district court held it, to bring it up to the Supreme Court. What do you believe the role of the federal courts should be in the arena of end-of-life decisions?
Well, there's a constitutional issue certainly at the bottom of that, and there are issues of jurisdiction. There are statutory issues, and Congress specifies the jurisdiction of the lower courts, and so Congress can give us a role in decisions of this nature, or Congress can keep the federal courts out of it and leave it to the state courts, where, for the most part, issues in this area have been adjudicated. But if there is a federal constitutional right involved, then someone may have then, of course, the federal courts have traditionally been a forum for the adjudication of federal constitutional rights. The underlying the constitutional issue is the one that the Supreme Court addressed in the Cruzan case and in the case of Washington versus Glucksberg. And this is obviously one of the most sensitive issues that comes up in our legal system and involves something that a lot of people have had to face, and a lot more people are going to have to face decisions involving the end of life. And with the advances in medical technology, this is going to be a very tough issue for an awful lot of people. And Cruzan the court proceeded on, they said, we assume that there is a constitutional right to refuse medical treatment that a person doesn't want. And there certainly has long been a common law right to refuse medical treatment that a person doesn't want. If somebody gives you medical treatment and you say, I don't want it, and they perform an operation on you or do something like that, that's a battery under the common law, and you can be sued. And the Supreme Court assumed that that was a fundamental right under due process, but said that there wasn't a violation of the right under the circumstances in Cruzan, where the state of Missouri had imposed certain regulations that had to be complied with before a person who was comatose could be taken off life support. And then in Washington versus Glucksberg, they addressed the issue of whether there was a constitutional right to assisted suicide, and they concluded that there was not, but there were, and they applied the standard to be applied under the due process clause for its substantive component, whether a right is firmly rooted in the traditions of our country and implicit in the concept of ordered liberty. But there were some concurring opinions that recognized that these were issues that were on the cutting edge of medical technology, let me put it that way, or that they were issues on which more empirical evidence might become relevant in the future.
Thank you very much. I notice I just have 40 seconds left. Will we have another round, Mr. Chairman?
Well, that's something that let's talk about. I would very much like to finish today. As I said earlier, that may be an ambitious schedule, but let's talk about it.
Thank you.
Senator Sessions.
Thank you, Chairman Specter. Judge Alito, I want to thank you for your patience and good spirit and your thoroughness in answering questions, and you've been very forthcoming. I think very few people could disagree that on case after case that you've been asked about, you've gone as far as you legitimately should go to express your understanding of the law and what's important there. I know your entire record has been examined extensively. You think about it, the FBI does a background check. They find out every place you've lived and talked to your neighbors and check your criminal histories, and the Department of Justice has a big inquiry that they do before they submit your nomination to the President, or the President submits your nomination to the Senate. The American Bar Association has interviewed 300 of your colleagues before they made their recommendation that you are well qualified in a unanimous vote. The Senate has its questionnaire. Outside groups look at it and create studies and data. They read everything you've written to find things that they might be unhappy with. And so I think all in all, you're coming through this with very little mud upon you, for which I congratulate you. I think it's something that you can be proud of. Most of us on this side of the aisle would not like to have our record scrutinized in the way yours has been. I know some of us have made mistakes in our statements already in the hearing. We have to admit. I'll admit that I was one of them. I first said that you were ranked number 4 in being the most independent judge out of 900 judges in the country. As I see the numbers more clearly, you were number 4 out of 98 appellate judges examined in that system, but that still shows that you're an independent, non-ideological judge, willing to, one of the factors they used was whether or not you always agreed with nominees of your party. And so I think that speaks well for your record, and that's why you've gained such a broad respect for your colleagues. You know, just want to briefly mention some of these studies that go into your background. People have looked at it incredibly to the most minutest detail. You were asked earlier about saying that you rule only 1 out of 8 times for immigrants seeking asylum. But looking at the asylum cases nationwide, most of those are the government's position is affirmed. It's already been decided by a lower court or administrative body. You're simply reviewing their decision. But In immigrant asylum cases nationwide, the Court of Appeals generally rule for the asylum seeker 11% of the time. During your record on the bench, you ruled for asylum seekers 18% of the time. And in your published opinions, the average Court of Appeals judge in America ruled for immigrants 8% of the time. In your published opinions, you ruled for them 19% of the time. So I think this not only shows that the charges against you there are not well placed, it shows just how carefully your record is being examined by people as you move through the system. Another example, civil rights. I think your critics have cherry-picked from some of your 4,800 cases that you've ruled on. In your opinions on civil rights, your panel was unanimous 90% of the time. And when you sat on a panel where both the other judges were Democratic appointees, your decision was unanimous 100% of the time. So I think that speaks well for your overall record on civil rights. Certainly would indicate that you're not hostile to legitimate civil rights complaints. You asked about one environmental case by Senator Feinstein, and you ruled on that case based on standing. That's an important issue in the legal system. Don't you agree?
It is. It's
well-recognized principle.
It's a constitutional principle.
It does not have to do whether you were for or against the environmental issue in question, but simply whether the person bringing the suit was a legitimate person to bring that suit.
That's right, and it doesn't have anything to do with Congress's power to regulate the environment under the Commerce Clause. That's a separate question. Congress, it's totally separate. One has to do with the scope of congressional power. The other has to do with who can bring the suit.
And with regard to environmental cases, you have rendered, according to one of these studies, you've authored 6 environmental opinions. You sided with the environmental regulatory body in 5 of those 6 opinions. Indeed, Professor Cass Sunstein, who has served as an advisor to the Democratic members of this committee on changing the ground rules of confirmation, which was really a precursor to the commencement of a filibuster, Professor Cass Sunstein has said this about you, quote, "This is a judge who, if the text is pro-environment, he's very likely to follow it. This is not someone who, like some judges, has a kind of pro-business orientation in his approach to the law." I think that's also a statement that you can take pride in. I would offer for the record, Mr. Chairman, another article by Stuart Taylor of the National Journal, Monday, December 12th, in which he, in a very effective way, dismisses much of the complaints that have been made against Judge Alito.
Without objection, that will be made part of the record.
The systematic this is his quote, "The systematic slanting, conscious or unconscious, of this and many other news reports has helped fuel a disingenuous campaign by liberal groups and senators to caricature Alito as a conservative ideologue. In fact, this is a judge who, while surely too conservative for the taste of liberal ideologues, is widely admired by liberals, moderates, and conservatives who know him well as a fair-minded, committed to apolitical judging, and wedded to no ideological agenda other than restraint in the exercise of judicial power." Close quote. And I would offer that for the record. Also, with regard to your challenges on Vanguard, on matters that have impacted your integrity, I would like to quote from the American Bar Association's interview questionnaires that they did on you among those who know you well. And this is what they put in their conclusion. Conclusion: "We accept his explanation and do not believe these matters reflect adversely on him, talking about those conflicts allegations. They go on to say, to the contrary, consistent with virtually unanimous comments from those interviewed include, he has utmost integrity, he's a straight shooter, very honest, and calls them as he sees them. These are quotes from different lawyers and judges. His reputation is impeccable. You could find no one with better integrity. His integrity and character are of the highest caliber. He is completely forthright and honest. His integrity is absolutely unquestionable. He is a man of great integrity. And then they conclude, on the basis of our interviews with Judge Alito and with well over 300 judges and lawyers and members of the legal community nationwide, all of whom know Judge Alito professionally, the Standing Committee concluded that Judge Alito is an individual of excellent integrity. So, congratulations on that finding. Judge Alito, many important decisions of the Supreme Court in recent years touch on the deepest values of the American people. They deal with things like Kelo and the property that they own, matters of faith and morality, decency and pornography. Do you have a sense of where the American people are with regard to these issues? Can you indicate to us that you have any appreciation for the legitimacy of some of those concerns?
Well, I do, Senator, and
regardless of the technical laws that involve, but just that fundamental policy.
I think I have an appreciation of people's concerns, certainly with respect to Kelo, which is a recent decision, and I can't comment on how I would rule on any matter concerning that, and it involved the power to take property for public use through eminent domain. I certainly understand that this is that what occurred in that case, which, as I understand it, was the taking of the homes of people of modest means for the purpose of building a large commercial facility that was thought by the city to be beneficial to the economic welfare of the city, that this is an enormous blow to the people whose homes are being taken. People live in homes and they have a sentimental attachment to them. They have memories that are attached to the homes. They can remember what happened in particular rooms. The neighborhood means something to them. The neighbors mean something to them. The things in the home mean something to them. And taking their home away and giving them money in return, even if they get fair market value for the home, is still an enormous loss for people. So I certainly can appreciate what they feel in that respect.
Well, let's talk about that a little bit, because this is a matter of real power, and it's a matter that the Congress gets drawn into sometimes whether we want to be drawn into it or not. We've discussed Roe versus Wade. People remain concerned about that. The polling numbers continue to drift against that decision. We talk about the district court opinion that I believe Senator Brownback raised, federal court on marriage, on redefining the traditional statutory definition of marriage contained in states and in state constitutions around the country. In Kelo, it's pretty clear to me that the court just changed the meaning of the words. The Constitution said you could take property for public use. The court felt that was too restrictive, basically, and a majority just changed it to say you could take property for a public purpose, which would include some private redevelopment of the area in their minds. See, that's not founded in the Constitution. That's an overreach, in my opinion. On the Pledge of Allegiance case, the Newdow case, the Ninth Circuit, which includes 40% of the people in the United States, ruled that the Pledge of Allegiance was unconstitutional. The Supreme Court sort of sidestepped the fundamental issue and said that there was not standing on behalf of Mr. Newdow and sent that back to a lower court. He now got him some plaintiffs that apparently have standing. He's taken it to the district court in California, and he's won that case. They've concluded that the Ninth Circuit law remains in effect so that 40% of the population of the United States really are not able, if you follow that opinion, to render the Pledge of Allegiance. Yet we have chaplains and in God we trust in the Senate chamber and all that, those kind of issues. So I don't believe that that is founded in the Constitution. I think the American people do not, and they're asking some real questions of us. So I guess I won't try to get you drawn into those, but I want to do this. The doctrine of judicial review, Marbury versus Madison. You already indicated Hamilton didn't favor that. But the court found it, but it's not expressly stated in the Constitution, is it?
No, it's not.
And it definitely shifts the balance of power between the branches because the court now has the power to, by a stroke of its pen, 5 of its 9 members, to strike down any law they say violates the Constitution. That's true, is it not?
Well, they decide constitutional questions, and the doctrine has been established since Marbury versus Madison. That's right.
Well, but there are explicit powers given to the Congress, and Senator Coburn raised some of those. Article 3, Section 2 has these words. In all the other cases before mentioned, this is the constitutional grant of power to the courts. The Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Now, those words are in the Constitution, are they not?
Yes, they are.
And if you said if they're in, the words are expected to have some meaning, you would give them some meaning at least, would you not?
I think that's undisputed, that they have a meaning.
And so Congress has some power here. We've not exercised that power, certainly in recent years. In Ex parte McCardle, the Supreme Court in 1869 agreed that though the judicial power is conferred by the Constitution, is conferred under such exceptions as Congress shall make. Then there's the impeachment power. Good Senator mentioned that. And then the establishment of lower courts. Article 3, Section 1 says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time establish. That indicates that Congress can establish or disestablish courts, does it not?
I think it's undisputed that the so-called inferior courts, and I don't particularly like the term as a judge of the Court of Appeals, but the so-called inferior courts are totally the creation of Congress.
Court of Appeals of the Federal Circuit was a special.
Now I'll just ask you to comment on this thought. Chief Justice Roberts, in his hearings, and I asked him some questions similar to this, indicated that he was concerned about activism by the court, overreaching by the court, and he felt that this overreaching had created a danger that it could undermine respect for law in our country. Do you share that view?
I agree that overreaching by the courts can undermine respect for law. Our authority is based on the belief that what we are doing is different from what Congress is doing. Because otherwise, why would people tolerate our functioning? Nobody elects us, and we have a system of government that is fundamentally democratic. It's based on the sovereignty of the people. So how do you explain an unelected branch of government making decisions? So all of our authority is based on the idea which was expressed in Marbury versus Madison, that the Constitution is law. It's not conceptually different from statutory law, and our job is to interpret the Constitution. It has a meaning and apply it to the situations that come up.
Well, right now, there's a strong feeling that I share, that the court on some very important issues that people care deeply about is exceeding its authority. They're calling on me and members and those of us in Congress to do something about it. I've got a lot of letters saying, withdraw jurisdiction. Why aren't you supporting legislation to do that? And Congress, I think, has shown restraint. But I hope that when you become a member of this august body, the Supreme Court, that, and I believe you will, that you will take those concerns with you and share with the members of the court that their views on policy issues are of no greater value than mine, frankly, at least in my opinion, they're not, and that the Congress has been showing some restraint here, but we really want the court to be more modest and to draw back from some of its intervention in policy issues that are causing much angst around the country. You want to comment on that? Otherwise, Mr. Chairman, I would yield my time.
Well, Senator, I think your policy views are much more legitimate than the policy views of the judiciary, because members of Congress are elected for the purpose of formulating and implementing public policy, and members of the judiciary are appointed for the purpose of interpreting and applying the law.
Thank you very much.
Thank you, Senator Sessions. We will now stand in recess until 4:20.
Okay.